Okay, welcome to the Assembly Select Committee on End-of-Life Care. Will the Secretary please call the roll?
Assembly members Edgeworth.
Here.
Gallant.
Here.
Gonzalez.
Here.
Moore.
Here.
And Chair Orentlicker.
Here. Thank you. Welcome to our Select Committee hearing this afternoon. Those joining by video in Las Vegas and those listening over the internet. So some housekeeping to start. Please silence your electronic devices. And if you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. When testifying, please remember to turn on the microphone. And here's the hard part. Clearly state your name and affiliation and spell your name. And every time, well, you only, and then turn off the microphone when you're done speaking. When we get to the testimony, I'll remind you that we do have time limits, but I'll remind you then. Members of the public may provide testimony by telephone as well as in person. If you want to call in, the number is 888-475-4499. Again, 888-475-4499. And you'll want to provide the meeting ID, which is 8897-65-12-826. I'll do that again. 8897-65-12-826. And then you'll press the hashtag when prompted for a participant ID. Meeting agenda and committee information is available on Nellis, which can be accessed through the legislature's website, and you can watch us on Nellis or on YouTube. We'll do public comment at the end of the meeting. Each person, whether you're testifying or doing public comment, will be limited to 2 minutes. And we have a handy timer there to remind you. We expect courtesy and respect in our interactions during the meeting. Even if we may not agree with each other, I don't expect consensus tonight, but it's very important that we respect each other. Committee members will be using their laptops to view handouts and other documents. Please do not view this as a sign of disrespect. They just want to make sure they're on top of the language for the bill and other exhibits. Okay, I think we're ready to open the hearing on Assembly Bill 346. This measure establishes provisions governing the prescribing, dispensing, and administering of medication designed to end the life of a patient. And Assembly Member Joe Dahlia, please come forward and introduce yourself. You've got some co-presenters, I gather.
Thank you, Chair Orentlicker and members of this Select Committee. Assemblymember Joe Dahlia, for the record, Joedalia, representing Assembly District 29. I'm here today proudly presenting Assembly Bill 346, which would legalize medical aid in dying for terminally ill patients that have demonstrated that they have not been coerced and are mentally capable of making the decision of their own accord. With me today virtually to co-present this bill are Elliot Malin, who will walk through the mechanics of the bill and the safeguards we've put in place, and Dr. Charles Blanke, who has had over 20 years of experience with end-of-life care in Oregon and is one of the nation's foremost experts in this field. I want to say at the outset that this is an important bill to a lot of people who don't have a voice right now. And those that are suffering are largely doing so in silence. So I also want to begin by thanking those that have brought forward this legislation before me. Senators David Parks and Edgar Flores were champions on this issue, and I'm proud to take up the mantle from them and continue their work. I'd also like to thank my co-presenters who do not have a client here today and are not making money off of this. They are here because they believe this is the right thing to do. The reason this bill came to me is because, unfortunately, I've had a few personal experiences that I believe underscore the shortcomings and, frankly, the failings of our current system. in our palliative and pain management options. I've had 2 family members pass away in hospice care under undignified circumstances over the past few years. But today I just want to talk to you about my dad because I think his situation really underscores the nature of the problem and why this legislation is so important. My dad, sorry.
Take your time.
Sorry. That's fine. So I think it's important that you know the type of person my dad was. He lived his life with humor, I'm so sorry, and energy, and he really had no reason to be that way. Because he had a really hard life, but he found a way to make something of it. Sorry. Right out of high school, he served his country in Vietnam, and it changed the trajectory of his life. He became a dad, a small business owner, and a beloved poker dealer in the Henderson community. There were people who came to play poker during his hours just to hang out with him. And I get why. And, no matter what kind of day he was having, you couldn't catch him without a smile and a joke. He wasn't always perfect. He wasn't always necessarily even a role model. But he was always my hero. Okay. In December 2019, that all kind of came crashing to a halt. He was hospitalized with end-stage COPD. The doctors weren't sure if he was going to make it out of the hospital. And they said that if he did, he had maybe a couple weeks. They would be defined by pain and fear. And what would eventually happen is, to those unfamiliar with COPD, it's a lung disorder. Essentially, his lungs stopped working. They told him he was eventually going to have a coughing fit, which he'd had for years. That wasn't new. But the last coughing fit would be different. Because it wouldn't end. He wouldn't be able to clear his lungs. So they were essentially telling him that he was going to drown above water. And hearing this, my dad being the way he was like, well, geez, doc, that doesn't sound great. Can I die any other way? I'll take car accident. The doctor did not advise he pursue that route, but we did pursue other options. The first thing we looked into was whether death with dignity was legal here. Obviously, we're here today. It wasn't. We also looked at where we could take him to because he really wanted to go out on his terms. That death did not sound good. He wanted any other way to do this. So we looked into it, but we were told by the doctor he would not be able to get on a plane because he was dependent on oxygen. No plane was going to take off with him in that state. And that if we drove him somewhere and he happened to have a medical emergency on the way, that we could be criminally liable for reckless endangerment. And that was enough for my dad to be uncomfortable with that option. He didn't want him dying on his terms to come at a price for anybody in his life. So that was off the table. But, the result of this is that he was trapped here. And ultimately, the hospice nurse that came to the home because he was in home care the final 2 weeks came by and promised us that when the day came, when that coughing fit came, that he just couldn't finish clearing his lungs, that she would come and she would take care of it, and that the current palliative care options were sufficient, and that a cocktail of morphine and Ativan would be sufficient, that he would drift off peacefully. That was not true. That was resoundingly untrue. When that day came, we called the nurse. She arrived. My dad couldn't even get a word out. When we called her, he just kind of gestured her card at us. And we called her, and when she arrived, she provided us with the morphine and the Ativan, and she gave us instructions on how to dispense it. And it was over 12 hours of misery. He was awake and struggling and gurgling and convulsing, and he couldn't communicate. He was suffering the entire time. When he did manage to say something, it was very brief, and it wasn't goodbye or I love you. It was, she promised, she lied, this effing sucks. He didn't censor himself, and I wouldn't have either. Those would be his last words. They were not close to the time of death. He continued to be in pain for several hours after that. But in those words and in that bed, I couldn't see my dad anymore. Not only did he not get the death he wanted, his family has to have that be the enduring image of him. So, because of the state of affairs, my dad died exactly the way he didn't want to die. Scared, slowly, and in unimaginable pain. And that was wrong. He should have had a choice in a state that prides itself on personal liberty and autonomy and self-determination. It strikes me as bizarre that the government of our state has any say in that final decision you make. That should have been his call to make alone. So for my dad and for all the folks that are suffering the way he did, I believe the time is now for us to fix this and allow terminally ill patients the freedom to write their own dignified ending. With that, I will pass the presentation over to my co-presenter, Elliot Malin, who will walk you through the mechanics and safeguards we've put in this bill, as well as the conceptual amendment we've prepared addressing stakeholder concerns.
Good evening, Chair, Orrin Lecker, members of the committee. Elliot Malin, ELLIOT, MALIN for the record. Thank you for hearing AB 346, or known simply as the End of Life Options Act. And thank you to Assemblymember Dahlia for being such a champion on this issue for Nevadans, and for keeping his father's memory alive and telling his story. What we aim to do is give Nevadans the dignity and respect at the end of life to make the choices that are right for them. I will be running through the bill for you today, the proposed conceptual amendments, and making a few observations for you. So existing law currently authorizes a patient who has been diagnosed with a terminal condition to refuse life-resuscitating or life-sustaining treatment in certain circumstances. Sections 5 through 33 of this bill authorizes a patient under certain circumstances to self-administer a medication that is designed to end the life of the patient. Section 14 defines practitioner to mean a physician, osteopathic physician, or advanced practice registered nurse. Sections 6 through 13, 15, and 16 define other relevant terms. Section 17 authorizes a patient to request that his or her attending physician prescribe a medication that is designed to end their life if the patient, 1, is at least 18 years of age, 2, has been diagnosed with a terminal condition by at least 2 practitioners, 3, has made an informed and voluntary decision to end his or her own life, 4, is mentally capable of making such a decision, and 5, is not requesting the medication because of coercion, deception, or undue influence. Section 18 prescribes certain requirements concerning the manner in which a patient may request a medication that is designed to end the life of the patient, including that the patient make two, not may, but must make 2 verbal requests and 1 written request for the medication, and that the written request for the medication be signed by a witness. Section 19 prescribes the form for the written request for the medication. Section 20 imposes certain requirements before a practitioner is authorized to prescribe a medication that is designed to end the life of the patient, including that the practitioner, 1, inform the patient of his or her right to revoke a request for the medication at any time, 2, determine and verify that the patient meets the requirements for making such a request, 3, discuss certain relevant factors with the patient, including the diagnosis and prognosis of the patient and alternative options for care. 4, refer the patient to a consulting practitioner who can confirm the diagnosis, prognosis, and mental capacity of the patient, and that the patient has not been coerced or unduly influenced. And 5, instruct the patient against self-administering the medication in public. Section 21 requires a practitioner who determines that a patient who has requested a prescription for a medication that is designed to end their life may not be mentally capable to refer the patient to a qualified mental health professional and to receive confirmation about the patient's mental capability. Section 22, sub 1 prescribes procedures for the issuance of a prescription for a medication that is designed to end the life of the patient, and sub 2 provides that only an attending practitioner or pharmacist may dispense such a medication. Section 23 prohibits an attending practitioner from prescribing a medication that is designed to end the life of the patient based solely on the age or disability of the patient, which I want to reiterate. Section 23 prohibits a practitioner, a physician, based solely on the age or disability of a patient to give them the option for medical aid in dying. Section 24 requires certain providers of healthcare to include certain information concerning requests and prescriptions for and the dispensing of a medication that is designed to end the life of the patient in the medical record of the patient. If a patient who has requested a medication that is designed to end the life of a patient transfers care to another practitioner or care facility. Sections 24 and 31 require the practitioner or healthcare facility that previously provided care to the patient to forward the patient's medical records to the new practitioner or healthcare facility. Section 27 prescribes certain information that must be reported by an attending practitioner to the Division of Public and Behavioral Health of the Department of Health and Human Services relating to a patient who has been prescribed or self-administered such a medication. Section 28 requires the division to compile an annual report concerning the implementation of the provisions of this bill, authorizing a patient to request a prescription for a medication that is designed to end the life of the patient. Sections 27, 40, and 43 of this bill provide that such information is otherwise confidential when reported to the division. Section 25 authorizes the patient at any time to revoke a request for a medication that is designed to end his or her life. Sections 26 and 35 of this bill provide that only the patient to whom a medication that is designed to end their life is prescribed may administer the medication. Section 26 establishes requirements for the disposal of any unused portion of the medication. Section 33 makes certain persons exempt from professional discipline and immune from civil and criminal penalties, and provides that such persons do not violate any applicable standard of care for taking actions authorized by this bill to assist a patient in acquiring a medication that is designed to end their life. Section 29 provides that a death resulting from the self-administration of a medication that is designed to end the life of the patient is not mercy killing, euthanasia, assisted suicide, or homicide when done in accordance with the provisions of this bill. And Section 2 of this bill requires a death certificate to list the terminal condition of the patient as the cause of death of the patient. Sections 1 and 3 of this bill provide that a coroner, coroner's deputy, or a local health officer is not required to certify the cause of such a death. Section 42 of this bill, 1, authorizes a coroner to make an appropriate investigation and after discovering that a person has self-administered a medication designed to end the life of the person to the extent necessary to determine the cause of the terminal condition with which the person was diagnosed, and 2, requires a coroner to cease such an investigation after determining that the terminal condition resulted from a natural cause. Section 41 of the bill makes a conforming change to revise certain internal references. Sections 30 and 38 of this bill prohibit a person from preventing or requiring a person to make or revoke a request for a medication that is designed to end of the life of the person as a condition to receiving healthcare or as a condition in an agreement, contract, or will. Section 31 clarifies that a practitioner is not required to prescribe a medication that is designed to end the life of a patient and remains responsible for treating the patient's pain. However, if a patient who is diagnosed with a terminal condition requests information concerning the prescription and self-administration of a medication that is designed to end the life of the patient, Section 31 requires, further, a practitioner provide that information or facilitate the transfer of the patient to another provider of healthcare. Section 31 also provides that a pharmacist is not required to fill a prescription for or dispense such medication. Section 32 authorizes the owner or operator of a healthcare facility to prohibit an employee or independent contractor of the healthcare facility or any other person who provides services on the premises of the healthcare facility from providing any services relating to prescribing a medication that is designed to end the life of a patient while acting within the scope of his or her employment or contract with the facility or while on the premises of the facility. Section 33 prohibits a healthcare facility or provider of healthcare from taking certain actions against an employee or independent contractor who, 1, provides accurate scientific information concerning end-of-life care to a patient, or 2, facilitates the prescription or self-administration of a medication that is designed to end the life of the patient. Sections 34 through 37 of this bill make conforming changes to clarify that a practitioner or pharmacist is authorized to dispense a medication that is designed to end the life of a patient that is a controlled substance or dangerous drug, and a patient may self-administer such a medication in accordance with other provisions governing medications designed to end the life of the patient. Section 39 of this bill provides that a proposed protected person shall not be deemed to be in need of a general or special guardian solely because the proposed protected person requested a medication that is designed to end his or her life or revoked such a request. Sections 44 and 45 of this bill prohibit insurers from conditioning life insurance benefits, group life insurance benefits, or the payment of claims on whether the insured makes, fails to make, or revokes a request for medication that is designed to end the life of an insured or self-administer such a medication. So again, life insurance companies cannot deny coverage for a person that utilizes this. Section 46 of this bill makes a conforming changes to reflect this prohibition on a policy of group life insurance. You all did also receive an updated conceptual amendment from me. I will run through those really quickly as well. And the first one is to change the death certificate to include a checkbox for use of medical aid in dying. The purpose is to ensure that the cause of death remains the underlying cause of death, the illness, while also providing a method for statistical capture and abundant honesty on the death certificate. We have heard from practitioners that they were not comfortable with what they felt was not being fully honest on the death certificate, and this would allow them to do so. Number 2, the doctor may only bill for the appropriate CPT codes for diagnosis and prescribing. This ensures this remains as close revenue neutral for providers, but able to receive compensation for services provided. Third, first responders, if called, must use the prescription used by the intended user as a do not resuscitate, a DNR. For this, the reason is if an individual third party calls emergency responders because of use of the drug by the intended and prescribed party, the prescription would act as a DNR to stop them from providing life-saving treatment. 4, first responders shall use the code, quote, medical aid in dying, end quote, for their impression on the reports if they respond to an individual who has ingested the prescribed medicine and the prescription was intended for them. The purpose for this one is to limit first responders from using the first impression of, quote, suicide on the reports to other providers and would fall in line with the rest of the provisions of the bill. And then number 5, revise section 11 to say, quote, understand the nature and consequences of the decisions, end quote. This would align section 11 with AB 461's definitions of mental capacity. Having now run through the bill and amendments, I want to address a few concerns that we often hear about this bill. But first, I remind the committee that it is unlawful under NRS 218E.085 to intentionally mislead the legislature, a legislative committee, or otherwise communicating to a legislature. When it comes to this bill over the years, we have heard numerous statements that have been factually unfounded and categorically false and oftentimes profoundly offensive. So to discuss those misconceptions, misconception number one, that insurance companies will offer this as an option instead of treating the patient. This bill requires the providers offer all options to the patient, and there is no history available in any state which demonstrates that an insurance provider does this. Misconception number two, that this will be used as a tool to, quote, euthanize, end quote, people with disabilities. I find this one to be the absolute most reprehensible of all of the preposterous positions. This bill clearly stipulates that only a person with a terminal illness with 6 months or less to live, having been confirmed by at least 2 doctors and having capacity to make an informed decision, is eligible for the prescription. A person with a disability has the ability to live their life to the fullest, and they also deserve the dignity and respect for people to recognize that. To be absolutely clear, a person with a disability does not qualify for this unless they have the capacity to make an informed decision that they are terminally ill with 6 months or less to live and is of the age of majority per section 17 of 23 of this bill. Misconception number 3, that doctors will charge in excess and turn this into a profit-bearing business. First, to be clear, doctors do have a right to earn a living. Second, our amendment aims to address this and makes providers able to reimburse the current procedural terminology or CPT codes. Misconception number 4, that individuals will coerce their relatives into seeking medical aid and dying. We have seen stories of this reportedly happening, notably an individual in Oregon. However, what is often misrepresented in that story is that that individual in question was denied access to medical aid and dying because the doctor followed the law due to the fear of coercion. That person was later granted the medication when doctors were comfortable that they were doing this of their own free will and coercion was not occurring. Per section 17, 30, and 38 of the bill, a semblance of coercion will require a provider to deny access to the medication. Misconception number 5. This will lead to a, quote, slippery slope, end quote, and this will allow people with depression access to the medication. Yet, in the decades that this has been permitted in various states in the United States, at no point has anyone tried to amend the existing laws to expand access to individuals suffering from mental anguish, nor does depression qualify an individual for this. Misconception number 6. This bill would lead to doctors who don't want to treat patients to offer this in lieu of treatment. Section 20 requires practitioners to provide all available options, including treatment, to a patient. Section 23 prohibits a practitioner from prescribing the medication based solely on age or disability. They must provide all available options. Misconception number 7. This bill would lead to denial of life insurance coverage and payouts for individuals who participate in medical aid and dying. Sections 44 and 45 specifically prohibit insurers from conditioning life insurance benefits, group life insurance benefits, or the payment of claims. Misconception number 8. This bill is, quote, anti-life, end quote. We agree that we must protect life at all cost. However, sadly, there comes a time when we can no longer do that. The person is going to die. If they have pancreatic cancer, for example, they will likely suffer a pain that I hope none of us ever have to experience. This is not a choice between life and death for these people. The choice for them is between suffering and not suffering at the end of life. It is disingenuous to paint this as an issue as being a life issue. It is simply not. It is not a choice we get to make for the patient. In last session, we had an individual, an activist, who was counting on us to get this done because they were suffering from pancreatic cancer. And unfortunately, we couldn't do it for them. And I had to tell that person how they were going to die, and that is exactly how they died in agony. Misconception number 9. This bill would subvert palliative care. At no point does this bill aim to subvert palliative care. It gives patients options at the end of life. Hospice and palliative care are great options for patients, but they are not the only option. Further, we have heard that we are advanced enough that we can make people comfortable at the end of life. This is largely true. However, it is not entirely true. As we just heard from Assemblymember Dahlia, that's not always the case. And patients deserve the dignity and the respect at the end of life to have an option. And we have also heard of cases where individuals have been administered excess drugs to ease pain, and that excess instead ends the life of the patient. Misconception number 10. This bill requires people of certain religious backgrounds to do something that they object to. This is patently false. As stipulated in the bill, we do not require anyone to do anything that they are uncomfortable with or object to. Every single Nevadan has a right to practice their beliefs free from a government mandate or government coercion. That includes the language of this bill. For example, I am a practicing Jew. I think that is not a secret to all of the members of this committee. As I don't want others to force their beliefs on me, nor do I want to do that to other people, other Nevadans. I would never want to do that to Catholic doctors, for example. The provisions of this bill under sections 31, 32, and 33 specifically permits people, entities, and employers to deny participation in any stage of this. Speaking of the Catholic Church, we know that the church remains in strong opposition to this bill. We have reached out to the church, and I hope to have a conversation with them soon to discuss how Catholic Nevadans must also be respected and how we do not want to force anyone to do anything that they object to or is not within their belief structure. That being said, I myself, like many Nevadans, am not Catholic. What works for me may not work for them and vice versa. This is a respect I must have for Nevadans who do not share my beliefs. It is a respect that I also expect in return. This is one of the fundamental concepts of the First Amendment's religious freedom protections, that we do not pass laws that favors one religion over another. In Judaism, we have a few rules, and as one of my rabbis recently told me in relation to this specific policy, and this bill in particular, the first rule in Hebrew is, V'ahavta l'recha kamocha, or love your neighbor as yourself. And the second, to do everything we can to save a life. However, we must remember that at times the second rule is not possible. We cannot save that life because that person is actively dying due to illness and is terminal, and God is calling them home. In that case, we must revert to the first rule, to love your neighbor as yourself, and to give them the dignity that they deserve to make the choice that is best for them, a choice of individual liberty, and one of the last comforts that they may know. Thank you, Chair, for the opportunity to be here today and to help present this bill. I will now turn it over to Dr. Blanky.
Good evening, and thank you to the committee for inviting me. My name is Charles, C-H-A-R-L-E-S, Blanky, B as in boy, L-A-N-K-E, M.D., M.D. I'm a tenured professor of medicine at the Knight Cancer Institute in Portland, Oregon, and a board-certified medical oncologist with an end-of-life specialty practice. My clinic focuses on medical aid in dying or MAID, and I have been participating in this field since 1998. I have written more than 500 prescriptions for lethal medication intended to end the suffering of patients with a wide variety of terminal illnesses. Over those 3 decades, I have attended several hundred deaths personally, and all of my patients died peacefully and without suffering. To the best of my knowledge, I've participated in the most MAID procedures of any doctor in Oregon, the state with the longest experience with MAID, and likely in the United States. I've also served as a MAID consultant for the states of Hawaii, New Jersey, and Washington, the Canadian Royal College of Physicians and Surgeons, and the French Ministry of Health, advising on practical applications once MAID legislation has been passed. I served as research director for the Academy of Aid in Dying, the largest medical professional organization devoted to MAID, and I have published and presented extensively on a variety of end-of-life issues. I have advised innumerable physicians and nurses on MAID practices. I consult weekly with physicians considering MAID for their patients, and I am quite familiar with community standards for actual MAID usage. Why do I believe MAID is a necessary option in end-of-life care? Because a small but significant fraction of patients suffering from terminal disorders like cancer are suffering in ways we cannot fix. Some are unable to interact meaningfully with their family or loved ones and thus have no quality of life. Others are more actively miserable. I have seen dozens of patients with nerve or bone pain that could not be controlled regardless of how much morphine was prescribed. They were truly living in agony. I am a huge supporter of palliative care, and I believe it is dramatically underused in the United States. But we cannot palliate the out-of-control symptoms of many patients at end of life. In fact, 25% of referrals to my clinic come from palliative care experts who've done everything else possible for their patients. MAID offers benefits to many who don't even take the medication. In fact, Oregon data demonstrate about 1/3 of patients prescribed lethal drugs each year do not self-administer them and instead die directly from their underlying disease. But having the medication available just in case things become unstable is unbearable, is a huge comfort to both patients and their families. Patients with these illnesses have almost no control over their lives, but MAID offers them complete control over their deaths. And knowing they have an option to relieve suffering should it worsen is a huge benefit that comes from legalizing the practice. I recognize there are concerns regarding potential abuse of the MAID laws. Some arguments were put forward even before the legislation first passed in Oregon in 1994. None came to pass. One fear, as you have heard, is that MAID might be foisted upon patients with disabilities to make things easier for families or for financial reasons. This simply does not occur, voluntarily or involuntarily. First, every U.S. venue in which MAID is legal requires a potential patient to have an underlying terminal disease to even be considered for that option. Terminal disease means an incurable and irreversible disease that has been medically confirmed and which will, within reasonable medical judgment, produce death within 6 months. It is not old age, chronic illness, or a disability as echoed in your own proposed legislation. Next, there are numerous safeguards against coercion, including a required demonstration by the patient that they are capable of making and communicating healthcare decisions by themselves. In fact, MAID is probably underutilized. I'm always asked when I lecture if it's even legal for a physician to offer MAID as one of many end-of-life options. Essentially, all of my patients say they had to bring the topic up on their own with their physician at their own instigation. So I know most doctors, in fact, almost no doctors, are offering it proactively. It is not being forced upon the impoverished or poorly educated. 73% of Oregon MAID users have attended college. Finally, families never tell a loved one MAID is their best option. MAID is certainly not euthanasia, the administration of lethal drugs, even with permission, to another person. That practice is illegal throughout the United States, and there is absolutely no evidence of a slippery slope from legalizing MAID to encouraging or allowing even a medical professional to take the life of a patient. Having MAID available does not lead to more people committing suicide. Several studies from Oregon and other parts of the United States prove the rate of non-assisted suicides does not rise in states where MAID is legal. Rather, it is possible MAID provides an effective and humane alternative to standard suicide for those seeking to end their suffering due to terminal illness. The drug combination now used throughout the US, known as DDMAPH, is highly effective, and it offers an incredibly peaceful and humane death to our suffering patients. It is both more reliable and safer than simply winging it, as you just heard so movingly from Assemblymember Dahlia, with hospice-prescribed narcotics or Valium. The median time to the patient being unconscious and completely unaware of pain, anxiety, shortness of breath, etc., is 6 minutes, with an average time to death of 96 minutes. 95% of patients die within a few hours, and that period is not in any way unpleasant for them. Other complications are quite rare. The scariest possible outcome for patients, of course, is the fear of waking up. While regaining consciousness from the MAID-induced coma is historically quite uncommon to begin with, at 0.3% of cases, no one has woken up with the regimen we currently use, and it has been used more than 2,000 times. I have learned quite a bit about how to make things easier for the patient and prescriber over the years I've been practicing. Nevada is already ahead of the game. For example, Oregon formally asked the physician putting the cause of death on official state paperwork to say drug overdose legally prescribed. Now, we simply list the underlying terminal condition. This has the added benefit of more safety in terms of insurance companies not being allowed to invoke a suicide clause. But I acknowledge it might present ethical challenges for individual physicians who know the immediate cause of death was actually the medication they prescribed. I commend Nevada for its honest but patient and physician-centric approach to that record keeping. Nevada is also far ahead of Oregon in anticipating problems I have learned about only through experience and try to address upfront in my clinic. In Oregon, we don't have statutory language to guide us. Advising patients on the procedure, how to store drugs, what to do with unused medication, and that it is legal for family members to help prepare the medication as long as the patient self-administers it is truly prescient. I will close in remembering another patient whose death I attended. I met a wonderful young woman with Lou Gehrig's disease, or ALS. She was becoming paralyzed and was slowly suffocating as she lost the ability to breathe on her own. She was terrified of what her end would look like, and she worried about its effect on her family. Instead, she self-administered medication with a host of caring friends and loved ones by her side. She slipped away peacefully, completely ending her potential and actual suffering. MAID deaths will almost certainly make up only a tiny fraction of Nevada mortality, as they do in Oregon and the other 10 venues where the practice is legal, but a much larger fraction would benefit from making it legal. I hope you pass this legislation. It helps many, many patients and would not endanger anyone. Thank you very much for this opportunity.
Are we ready? Do you have any more before we move to questions?
No, thank you, Chair. We're ready for questions.
Okay. Assemblymember Gonzalez.
Thank you. And thank you so much for your presentation. I really appreciate the courage that it takes to tell your story here in the public. So I appreciate that. Thank you. My question is regards to, and I apologize, we went over the bill kind of rather fast there. What is the, I see folks shaking their heads up there, so yes. Do we know what the time frame will be from when a patient requests medication to when they actually get that medication?
Elliot Mallon record. We do. Let me find that for you. There's two different time frames. There's the one where they are imminently going to die. So the first part is they have to make the first request, and then they have to wait 2 weeks for the second request, and then do the written form. In cases where an individual doesn't have 2 weeks, or 14 days, I believe it was, they are shortened, and they can make the request, if I'm not mistaken, immediately. So it is 15 days. I apologize.
For what it's worth, 15 days is the most common period among the 11
Dr. Blanky,
venues where
please state your name for the record.
Sorry, Charles Blanky speaking. I just wanted to add that 15 days is the most common waiting period, although it varies from immediate to that time frame.
Thank you so much for that. Chair, may I have a follow-up, please? Thank you. So if I'm the patient and I request this option and I go through the process, from the time that I make the request, it's 15 days in which I would actually have that medication in my hand. Is that correct?
Elliot Mallon, for the record, not necessarily correct. So there's the first request, then you have to wait 15 days to make the second request, and then you have to make the written request. From what I understand, the written request and the second verbal request can happen almost simultaneously. And then at that point, the physician has to contact, and you have to remember in this process also has to go with a second diagnosis and prognosis. So you have to see a second individual doctor. But after all of that is done, the attending physician then must get your consent to notify the pharmacy, give you the prescription, and then send the prescription to the pharmacy. So at that point, the prescription has to be filled by the pharmacy. And at that, I don't know how long that could take. Pharmacies are quite different, and Dr. Blanky might actually know a little bit more on that part of it.
Certainly. So Charles Blanky, for the record, when I get the first request from my patient, I get a sense of how urgent the situation is for them. And I discuss the legally mandated waiting period if they're not imminently dying, which is 15 days in Oregon. If they want, and I always ask them what they want, I will set up that second appointment on day 15. I will try and get that second opinion during the 15 days. We have a little bit of a difference in that there has to be a 48-hour waiting period between the written request and the prescription writing. So we try and do that before day 13, so it doesn't wind up being 17 days, if that makes sense. But I also tell them that the pharmacy usually has the medication in stock and usually will do same-day filling, but they do need to be prepared for the possibility that it will take the pharmacy a couple of days.
Thank you, Chair, and thank you, Assemblymember Dahlia, for being so willing to share with us your story. I know it's hard, so really appreciate that. I do have a question, and I don't know if this was covered during the presentation because we went through it pretty fast, but on section 18, where it talks about on section 18, subsection B, where it talks about the written request for the medication, on page 8, there's a form that states all the request for medication, form that people have to fill out. One question is, once they fill that form out, who will keep this on file?
Elliot Mallon for the record. So the attending physician should also be the one that keeps this on file. The patient should keep this on file. This is a little unique to Nevada. We offered this up for the first time last session to ensure that people were making informed decisions for themselves. But to fully answer the question, the attending physician should be the one that keeps this on file, as well as the patient. And Dr. Blanke, you might have some input on that.
Yes, I'd have to look back at your legislation to see what forms have to be submitted to the state, the health authority, but there is a requirement to do so. In Oregon, we have to submit paperwork shortly after we write a prescription, whether or not the patient takes it. And that information includes the attending physician's opinion, the consulting physician's opinion, and that written record. So the state also has a copy of it. Needless to say, I keep a copy myself.
Oh, may I have a follow-up? Yeah, just a quick follow-up. Thank you for that answer. Regarding the form, I didn't see anything on the bill mandating or suggesting that this form be made available in other languages other than English for folks who prefer to receive their information in their native language. Is that something?
Elliot Mallon for the record. Sorry, go ahead.
Oh, go ahead.
I was going to say, I am Elliot Mallon for the record. I'm making a note of that right now, and I will talk to the sponsor about amending Section 19, since we already have amendments, to include the availability in native languages for an individual, as long as it conforms to the same translation.
Charles Blanke here, and in Oregon, we do at least have a Spanish version.
Thank you.
Thank you, Chair. Thank you for sharing your story. That was a lot. I really appreciate it. No, but that's not very many people are brave enough to tell their whole story, and it's a lot. Thank you for giving us that background. I have a question. In Section 21, I'm not going to get too technical because I'm just a doctor, but my question always would be that I would want somebody to be have the capacity to make this kind of a decision, and this could be Dr. Blanke who answers. My question is, it's my understanding the attending would decide if the person had the capacity to make a full decision, and then it says in Section 21 that should they not be able to make the determination that's a person professionally qualified in the field of psychiatric mental health. I'm not sure what that means. My question is, does that happen often that we refer to a psychiatric person? And if we did, is that usually a psychiatrist or a therapist, or who would be that person?
Charles Blanke, that's a great question. So either the attending or consulting physician, the second opinion, have the right to ask for a psychiatric or psychological evaluation if there's any question about decisional capacity. That actually very rarely occurs. It's about 3% total over the history of the Oregon bill and now law. In some years, it's 0%. So for whatever reason, we think that we're pretty good as doctors at certifying whether the patient truly understands what's going on. Supporting that, I will tell you that on rare occasions, I have sent people 95% of them are certified as capable. And those were situations where I was myself uncertain. We can use a psychiatrist or a psychologist. In other states, it's actually even broader, I believe, although I wouldn't swear to this on the record, but I believe in Hawaii, it could be other mental health specialists outside of psychiatry and a PhD in psychology.
Yes, thank you. David Orentlicker, our counsel, Eric Robbins, we have this set out in statute.
Yeah, Eric Robbins, LCB Legal, for the record. So, person professionally qualified in the field of psychiatric mental health is defined in Section 12 of the bill to have the meaning ascribed to it in NRS 433.209. That section defines person professionally qualified in the field of psychiatric mental health to refer to a psychiatrist, a psychologist, a marriage and family therapist, a clinical professional counselor, or certain social workers and registered nurses who have advanced psychiatric, like master's level psychiatric training. It would have to be a clinical social worker, and the social worker and the nurse are also limited to people employed by the Division of Public and Behavioral Health of the Department of Health and Human Services.
Thank you.
Charles, thank you. That sounds almost exactly like Hawaii to the best of my recollection.
Other questions from members? Okay. Assemblymember Gallant.
Sorry, when you asked, I was still thinking about the legal definition of a psychiatrist, so I apologize. Okay, I have a question. In Oregon, you said that you had to notify the Department of Health pretty quickly, and on our bill it says within 30 days of prescribing the medication, and then within 60 days after the patient has passed. Is that in line with Oregon, or do you guys have quicker timelines in terms of reporting?
It's actually 10 days. It's in line, but ours is a little teeny bit shorter. I will say that every once in a while, patients, we're not aware of their deaths, particularly if they don't take the medication and they die of something else very far down the line. So I've tried to put a checklist into my chart note so I can come back to it later. For what it's worth, the health authority they've been very, very diligent in collecting that data, but they're not out to punish doctors who don't do it within that time frame.
Okay, follow up? That's okay. So here's my next question. So you had also explained that you'll prescribe the medication. It's like peace of mind for them to have it. A lot of times they end up not taking it and dying of natural causes. So what is the process in terms of that medication sitting in the medicine cabinet? Is there anything where the family has to return it? What would that process look like?
It's a great question. So first of all, the Oregon statute's a little bit, Charles Blanky here. The statute's a little bit interesting in that the prescription does not go directly to the patient. It must go to the pharmacy. The advantage to that is they will hold it, which has a financial advantage in that if the patient doesn't take it, they're not out the $800. But it also means that they have less time when that medication is at home. On the other hand, they do bring it home and they don't, well, first of all, if they bring it home, I do tell them that they need to be very careful with the medication and treat it as a potentially dangerous substance. So potentially if they have a gun safe, I always preventatively advise them to put it in a safe, and that's sort of the standard for the professional organization that I belong to as well. I'm fairly sure your statute mentions how to store it and how to dispose of it. In terms of the latter, I advise them on local pharmacies that have a drop box, or to be honest, I'll offer to pick it up myself so the family doesn't have that additional stress.
Okay, thank you.
Other questions?
Thank you, Chair, for the second question. During the presentation, Oregon has been cited a lot and mentioned, and I understand it's the first state to have ever passed this, but how many other states have this already as in their laws?
So there are Charles Blanky here. There are 11 U.S. venues where medical aid in dying is clearly legal. I say venue instead of state because Washington, D.C. is one of them. Most of them have had either ballot initiatives or direct legislation that allowed it. Montana has legalized it through a Supreme Court ruling. What I can tell you, which I believe you're indirectly asking, is that every state does collect data on the use of medical aid in dying, and it's remarkably similar across all 11 venues. Cancer is always the most common underlying illness. The people are always well educated for whatever reason, and it's just remarkable how similar the outcomes are in those 11 venues. I believe that there are 16 states currently considering it this legislative session.
Thank you.
Any other questions? Okay. as you said, Dr. Blanky, Oregon's had almost 30 years of experience. How many times have physicians had to be disciplined for not employing the statute properly?
Charles Blanky here. It's rarer than hen's teeth. In fact, the 2024 report just came out, and as usual, no one was disciplined. I don't want to make up a number, but I believe it is under 5. People really try and do this in good faith, and the law is there to protect the patient and is in general very well applied. But I will tell you, I look at the report every year, and I only remember one case where it actually happened.
Thank you.
And it was, to be honest, yeah, it was just one case.
Other questions? Okay, I think we're ready to move on to testimony. But before we do, we've been at this for almost an hour, so let's take a 5-minute break, and then we'll come back to testimony. Okay, let's reconvene. We'll now be ready to move to testimony. I know there are a lot of people who want to testify, and we're eager to hear your testimony. That said, we do have limited time, so we're going to allow 30 minutes for support testimony, 30 minutes for opposition testimony, and 30 minutes for neutral testimony. We'll also, for each person, 2 minutes maximum. There is a timer there. Please be mindful, and we'll remind you as we're getting close to your 2 minutes. But I do need to be strict about it because there are a lot of people who want to testify, and the longer person A speaks, the fewer people can speak, and better to have more people. So we'll be strict about the 2 minutes. It is fine if you're the 10th or 15th person to say, I want to echo the comments of the previous speakers, and no need to use your full 2 minutes. Again, be respectful. Please remember this is the hardest part, to state your name and to spell your name, because our transcribers don't know everybody in the room, so please. And fairly slowly. So I have trouble keeping up with some of the spellings. All right, we're going to start with support testimony. Those of you who are in Carson City, come forward after you complete your testimony. Please go back to your seat so the next person can come. And then we'll just keep filling, and we're going to, as I say, so we'll start here. We'll start with, because I see there are people in Las Vegas too. So we'll start with 10 minutes here, then we'll go to Las Vegas, and then do some rotating. So please start when you're ready.
Good evening, members of the Select Committee on End-of-Life Care. My name is Dr. Sandra Koch, and I represent the Nevada State Medical Association, the oldest and largest organization representing physicians in our state. At our core, the Nevada State Medical Association is a patient advocacy organization. Our physicians believe that their first and foremost duty is to provide the best possible care for patients, supporting them through both their health and suffering. Our members recognize that end-of-life choices for their patients are deeply personal and should be made with dignity, autonomy, and respect. 82% of Nevadans support legislation, such as the bill that you're bringing today. 79% of Nevadans, this from a survey in 2023, personally want the option of end-of-life care. Therefore, we are in support of AB 346. Thank you.
Good evening, Committee on End-of-Life. My name is Maximilian Lowe, L-O-W-E. AB 346 provides individuals the right to choose to end their life if they have an end-stage disease which is uncurable and have been through extensive medical treatments. This bill provides options to make their own decisions about their end-of-life care that works for them. This is not doctor-assisted suicide, but about an individual's right to decide their end-of-life choices. AB 346 is about choice and self-determination. Please support this bill and individuals' right to self-determination and respect their right to their choice for their decisions. Thank you.
Elizabeth Grimm, for the record, ELIZABETHGRIMM. I come before you to support the Death with Dignity bill from a deeply personal story. As a teenager, I battled an illness that took 8 years just to diagnose. What followed was 4.5 years of grueling treatment, daily IVs, and a chest port, and countless medical appointments. My quality of life diminished to the point where I slept 22 hours a day. This was how I spent my 20s, years that should have been filled with growth and opportunity. My doctors supported my withdrawal from college, uncertain if I would survive my treatment. I was placed on palliative care. Though I fought for my life every day, my existence was reduced to a bare minimum of living. During that time, I learned about Death with Dignity legislation. While I wasn't ready to make that choice for myself, knowing such an option existed in other states provided a kind of comfort. The knowledge that if my treatment stopped working and my life continued to diminish, I could work with my doctor to end my unbearable suffering with dignity. This bill isn't about choosing death. It's about empowering people facing terminal illness to have a sense of control. It's about valuing quality of life over quantity of days. Today, I am grateful that I am before you healthy with a full life ahead of me. But I speak for those who face what I faced, a life diminished by medical circumstances beyond their control. The safeguards in this bill ensure that these decisions are made with medical oversight, sound judgment, and compassion. I urge you with every fiber of my being to support this legislation that honors human dignity and life's most vulnerable moments.
Good evening, Chair and members of this committee. My name is Catherine Nielsen, and I am the Executive Director of the Nevada Governor's Council on Developmental Disabilities. Medical aid in dying is sometimes incorrectly referred to as assisted physician suicide, physician aid in dying, death with dignity, and euthanasia. Medical aid in dying is not assisted suicide, suicide in general, or euthanasia. These terms are misleading and factually incorrect. Medical aid in dying protects patients, affords dying people the autonomy and compassion during the most difficult time. It actually improves end-of-life care and would cost our state almost nothing to implement, except for the minimal costs associated with collecting data and producing the annual statistical reports. The Nevada Governor's Council on Developmental Disabilities supports the individual's right to make informed choices on decisions that will impact their life. This includes their rights to make end-of-life informed choices, and we did submit a longer piece of testimony for you guys to read as well. Thank you.
Thank you, and just please spell your name before you wrap up.
Catherinenielsen. Thank you.
Good evening. Thank you, Chair and Committee, for holding this space. I'm Melissa Chancel Harry. It's spelled Melissa, last name ChansellE-Hary. I'm the founder and owner of Sacred Transits, and I'm a member of the Doula Co-op of Nevada. I'm an end-of-life doula and a Reiki practitioner. I help people before, during, and after death. This option is crucial, and it's desperately needed. No one can predict how their end will come. And I've seen and worked with families who believe that they know their wishes and desires, and they have them, and then they change when the reality of their situation becomes clear to them. Palliative care and hospice care are amazing and incredible resources that are also drastically underutilized, and they don't provide the full spectrum of care that's needed. This is a critical option that's missing that we have an opportunity to change. We have a death-phobic society, and I see care teams resist acknowledging that death is even likely when we have a diagnosis. This bill will not cause the pendulum to swing so far that it's used inappropriately, and the language is responsible in making sure and preventing any of the fears that have been listed previously and currently. I think you're going to hear some difficult opposition today to this bill, and I urge you to consider which statements are ideological in nature and which ones come from lived experience. One of your own is here today, and because of what he had to endure and because of what he continues to carry. And other people are speaking from their lived experiences. Because for those in favor, it's because they've lived through or are currently living through an excruciating experience and are looking for a type of relief and solace. Please hold close what is from lived experience and what is not. And thank you so much for considering this bill. Thank you.
Good evening. My name is Tia Smith, Tiasmith. I'm a policy attorney with ACLU of Nevada. We strongly support AB 346 because it affirms the fundamental right of every mentally capable adult to make deeply personal decisions about their own body, health, and end-of-life care. This legislation empowers terminally ill people to preserve their dignity and autonomy by allowing them to choose a medically guided and voluntary path that ensures patients and not the government retains the right to make informed decisions based on their own values, beliefs, and quality of life. Respecting bodily autonomy at the end of life is a compassionate and just policy. We urge the committee to support this bill. Thank you.
Good evening, Mr. Chair and committee members. My name is Dr. Timothy McFerrin, MCFARREN, and I'm just a physician like Dr. Edgeworth. The majority of physicians and nurses support this end-of-life care, and I urge you to support it also. Thank you.
Thank you. We'll now go to Las Vegas. People in support in Las Vegas, please come forward. On the phones, do we have anybody on the phone calling in support?
If you would like to testify in support of Assembly Bill 346, please press star 9 to take your place in the queue. Again, if you wish to testify in support of Assembly Bill 346, please press star 9. Caller, please press star 6 to unmute yourself.
Hello? Hello. My name is Dr. Johanna Koch, K-O-C-H is the last name, J-O-H-A-N-N-A is my first name. And I am a hospice and palliative care physician working for the Summit View Hospice in Reno, Nevada, as well as working in California. I am a prescriber of medical aid in dying since 2017 in California. And I feel as though the physicians and representatives who have spoken today have spoken from the heart and have spoken the truth as I see it and as I have experienced it. I had prepared some statements, but they feel redundant now, so I just wanted to clarify 2 small points. And one is that in California, the requirement for reporting of a death is 30 days, just as it is in Nevada, which is a reasonable length of time for family to come to terms and physicians to get their paperwork done. And then the second is regarding destruction of medication. As a hospice physician, when we have a patient who is prescribed medical aid in dying but does not take it, we take that medication back, and there are formal processes for destroying it. We do not leave it in a patient's home, and while it is in their home prior to ingestion, we always require that they keep it locked up, as was mentioned. So drugs are not left in a situation where they can be misused, misdirected, or in any other way used inappropriately. Thank you so much, and I am obviously in very strong support of this bill.
Thank you. Next caller, please.
Hello, Chair and members of the Select Committee. My name is Emily Barney, for the record, EMILYBARNEY. I am a co-founder of the Doula Co-op of Nevada. I am also an end-of-life doula. And just as Johanna has shared, all of the presentation of this bill and testimony before me urges the truth of this bill and what is needed desperately in Nevada and across the country for folks who are experiencing suffering at the end of their lives. So I ditto everything that everyone has said, and I thank you for your time and consideration of this bill. Thank you.
Thank you very much. Next caller, please.
Thank you, Chair and members of the Select Committee. My name is Isla Ludwig. For the record, ILLIA, Ludwig, LUDWIG. I am calling in support of AB 346. I have personal experience with my uncle choosing to use MADE in Hawaii. His diabetes was going to end his life in a way that would cause him to suffer. He chose an option that allowed him to die peacefully and with dignity, and I am in complete support of this bill. Thank you so much.
Thank you. Next caller, please.
Good evening, Chair and members of the committee. Thank you for your opportunity to speak this evening. My name is Tiara Flynn, Tiaraflynn. I'm a professional birth, postpartum, and full spectrum doula here in Nevada. I'm here to express my support and echo the sentiments of those prior to me for Assembly Bill 346. Although my work is centered around the beginning of life, I see undeniable parallels between birth and death. Both are deeply personal experiences that deserve compassion, dignity, and most importantly, autonomy. I recommend that this bill move forward without delay. No one should be criminalized for choosing a care path that feels right for them. Again, in closing, I urge you to support AB 346. Every person deserves the right to decide how they meet death with agency and peace. Thank you again, Chair and members, for your time and for everyone that shared their testimony today in consideration for AB 346.
Thank you, caller. Next caller, please.
Hello, good evening, members of the committee. My name is Gina Schneider, and I am the Regional Campaign and Advocacy Manager for Nevada at Compassion and Choices Action Network. We advocate for legislation to improve the quality of life for terminally ill patients and affirm their right to determine their own medical treatment options as they near the end of life. We have been working with people of Nevada since 2017 to authorize medical aid in dying. We support legislation that has authorized the time-tested practice of medical. Action Network supports the original bill as written, and Compassion Choices Action Network will have to review the additional amendments before we can comment on them. Thank you.
Thank you. Next caller, please.
Caller, you are unmuted on our end. Please go ahead.
Yes, hello, members of the committee. Ian McIntosh, IANMCINTOSH, Executive Director for Not Dead Yet, on behalf of members in Nevada and as a Canadian with disabilities living in America, I urge you to oppose AB 346. Unwitting ableism takes many forms.
I'm sorry, we're in
legislation
support
that discuss-
testimony, Mr. McIntosh. So we'll bring you back for opposition. Is there anybody calling in support? Anybody else?
Thank you, Chair. We have no additional callers in support at this time.
Thank you. Before we move on, is there anybody else here in Carson City who wants to testify in support? Or anybody in Las Vegas? Okay, then we can move to opposition testimony. We'll start first in Las Vegas, Carson City. And you can also get ready in Las Vegas too, but we'll start here in Carson City.
Thank you, Mr. Chair. My name is Melissa Clement with Nevada Right to Life, testifying in opposition to AB 346. States that have passed laws to legalize assisted suicide have followed a pattern of enacting legalization with supposed safeguards only to come back and claim they are barriers. State laws have been expanded by subsequent legislation, court action, and interpretation. Oregon, Washington, California, Vermont, Hawaii, and Colorado have passed legislation or used the courts to expand their laws to allow individuals less qualified than physicians to prescribe lethal drugs, reduce or eliminate waiting periods, and remove residency requirements. In Colorado and Oregon, physicians have interpreted their laws to allow the deaths of patients with anorexia, a mental health disability not envisioned when the law was enacted. California recently considered an expansion bill to remove the 6-month prognosis requirement, allow dementia patients to request lethal drugs and allow self-administration of the drugs via IV infusion. The bill was withdrawn after one supporter stated it was moving too fast, too soon, providing a vision of where proponents eventually want to go. Nevada legislators can rest assured that should Nevada enact an assisted suicide law, proponents will come back for more in a few years. Please vote against AB 346, not only to protect patients at the beginning, but in the future. Thank you.
Thank you. Next.
Hello, my name is Dr. Kirk Bronander, KirkBronander. I am testifying in opposition to AB 346. My testimony is my own. I'm not representing my employer or the hospital where I work. I've been practicing in Nevada for 23 years. I'm a hospital medicine physician in Reno, and I frequently deliver bad news to patients, give poor prognosis, and explain end-of-life options. I'm completely opposed to this bill for many reasons. Due to time, I'm just going to highlight a few. Number one, the prognosis of a patient with a terminal condition is very difficult, and we are often wrong in this prognostication. How do we determine whether a patient is likely to die in 6 months? It's an educated guess. Many people outlive that 6 months prognosis on hospice, meaning that people that end their lives in this way could have lived for years. Former President Jimmy Carter lived almost 9 years with metastatic melanoma in his brain. He would have been a candidate for medical aid in dying from the first time he was diagnosed. A study in the American Journal of Hospice and Palliative Care found that physicians are wrong in prognostication 50% of the time. This bill, number two, this bill also requires that an attending physician inform patients diagnosed with a terminal condition of this, quote, option, as if this option is healthcare. The original Hippocratic Oath states, quote, I will not give a lethal drug to anyone if I am asked, nor will I advise such a plan, end quote. Yet this law insists that I violate my conscience and my oath and inform a patient I've just diagnosed with a terminal condition that they can take up this option. I should not be forced to do this against my conscience. Thank you.
Thank you. Next, please.
Thank you, Chair, members of the committee. I'm Jason Guanasso. My name is spelled Jason. My last name is spelled Guinasso. I am here as a private citizen representing myself, and all my opinions and perspectives are my own and not any organization or employer that's attached to me. I come to you with over 2 decades of experience providing pastoral care to the dying, and I understand that the central premise of AB 346 is to alleviate suffering at life's end. And I think this is a goal that we all share. However, I want to emphasize that the means to that end matter profoundly. Proponents present this bill as compassionate, but true compassion doesn't abandon patients to death when they're the most vulnerable. True compassion walks line-suffering people, addressing its root causes of suffering. Giving people the means to end their life rather than providing comprehensive palliative care isn't mercy, it's abandonment. AB 346 presents a false choice, either suffer unbearably or end your life. This is a failure of a medical system and our imagination. Oregon's been cited a lot before you. The Oregon studies, however, show that physical pain isn't even among the top 5 reasons people request lethal medication. In fact, the Oregon Health Authority's report in 2003 on death and dignity says that physical pain isn't even among the top 5 reasons for lethal medication. Instead, loss of autonomy, decreased ability to engage in activities, and loss of dignity top the list. These are all issues that we can and should address through holistic hospice care without resorting to assisted suicide. The fundamental question isn't whether we should address suffering, it's really how. Will Nevada be a state that invests in palliative care, extended hospice access, and family support services, or will it take an expedient path of offering death instead of dignity? A holistic approach is what's required for complexity of human suffering at the end of life, not lethal prescriptions not lethal prescriptions. If hospice care and palliative care...
I need you to wrap up. I'm sorry, but please wrap up.
If hospice care and palliative care is a burden, then we should fix that if it's broken, not prescribe death. So I urge you to oppose and vote against AB 346 and support other holistic options for compassionate end-of-life care. Thank you.
Hello, my name is Jason Lewis, Jasonluis, and I am here on my own, and I'm not here representing my employer or anyone else. I am a survivor of terminal cancer. I currently have an uncle who is diagnosed with, he's in stage 4, and he was given less than 6 months to live, and he is currently, because of medical innovation, he is currently 7 years past that point. To say, the reality is the only one who benefits from this is the insurer. And to say that there is not a cost incentive is intellectually dishonest, and it's disingenuous. I see it every day in what I do for a living. I'm in the workers' comp arena, and I see how insurers delay treatment. I see the frustration that comes from that. I know firsthand what it is like to be diagnosed with a terminal illness. The fear that comes along with that, the depression. The first thing that goes through your mind is, oh my God, I can't put my family through this. Everyone would be better off if I wasn't here. The financial burden that I'm going to potentially put on my family. Where the insurer comes in, all it takes, it's not them saying, you know what, this is what you need to do as a viable option. All it takes is delaying treatment. And to say that there's not a financial incentive to do that. Delay it. When you're dealing with someone who is depressed, when someone is in pain, all that does is presents an option over here where I don't want to put my family through something like this. And I think it's dangerous. I think it's reckless. And I pray that you guys vote no on this. And above and beyond that, I think this is something that
I'm sorry, we do need you to.
Yes, sir.
Wrap
I think
up.
this is something that is better off going to the voters than it is a legislative enactment.
Thank you. Next, please.
Hello, my name is Deidre Hammond, and I spelled it with a business card over there. I'm a parent of a young woman with a disability, and now that I'm becoming older, I also have a disability. I do want to say thanks to the Democrats who bring this bill up again and again and again. We've been here since 2009 when we convinced Bernice Matthews that this is not good for the disability community. This is a bad bill for the disability community. And now we have a committee, and I think that's great in terms of addressing palliative care and hospice, but this bill needs to be withdrawn. And it was so interesting to listen to Mr. Dahlia because he gave us the answer. He didn't even realize he was doing it. His father said that he did not want his dying to come at a cost to anyone else. And all change is hard, all loss is hard. Most of us struggle with thoughts of suicide, just as we just heard. In Nevada, we have an Office of Suicide Prevention. But this bill calls for us to create a separate office where disabled people who have been labeled terminal will be sent to be coerced to death without regard for their mental health or access to home and community-based services and case management to assist them with the adjustment. As disabled citizens who are so at risk from this law, we want you to understand that we have the right to be free from a danger created by the state to increase and encourage our suicide. In addition, the bill removes compliance with many ordinary standards of care in medicine and shuttles people to doctors who cannot be held responsible for egregious actions or malpractice they might engage in. Just like Dr. Kevorkian, who ignored Thomas Yoke as he begged him to stop. When asked later, Kevorkian said, never could understand anything that guy said.
Yeah, I do need you to wrap up, please.
Yeah, we ask the sponsors to pull this bill and proceed with the important work of strengthening hospice.
Thank you. And now we'll go to Las Vegas. So if you all start down there, please.
Good afternoon, good evening. I'm Henry Rex Green, Henry, Henry, Green, Grene. I am a board certified in hematology, oncology, hospice, and palliative medicine, and have nearly 50 years' experience caring for dying patients. I have given them aid in dying without handing out a lethal overdose. I've served on the ethics councils of the CMA and AMA. Of the nearly 2,000 patients that have died under my care, yes, that's the number, a dozen requested enough pills to end their life. None did so because simple counseling and a couple of doses of a mood elevator sufficed. However, there are terminal symptom crises, and I express my sincere sympathy with the assembly member whose father had such a terrible death. I wish I had been across him at the poker table. Now we hear from Oregon that they are doing this practice, which is euphemistically called MAID, for anorexia, arthritis, blood diseases, non-lethal conditions, non-terminal conditions. Oregon reports consistently a 2.7% rate of referrals to psychiatry. In short, they've created a parallel medical universe in which a request for lethal drugs does not count as suicidality and is not even worth psychiatric evaluation. The range of outcomes in Oregon is from 1 minute to 137 hours. Think about that. Yes, the average is 2 hours, but 137 hours suggests that somebody performed a coup de grace, and 1 minute suggests the patient could not possibly self-administer the medications per the terms of the law.
And I'll have to ask you, I need you to wrap up, please.
The reasons for asking for this procedure were psychosocial issues known as a...
I'm sorry, I please, you need to move on to the next speaker. Thank you.
Good afternoon, legislators. My name is Leslie Quinn, and I offer my sincere condolences to the young man that spoke about his dad. I oppose AB 346. A 2018 article noted that the European country of Belgium has some of the most permissive laws regarding euthanasia of any nation in the world. Now Belgium allows children of any age to choose euthanasia. Within 2 years of that article, 3 children ages 17, 11, and 9 chose euthanasia. One child had cystic fibrosis, another muscular dystrophy, and the third had a brain tumor. Doctors decided there was no hope for these children or reason for them to continue living, so their lives were ended at their request. That same year, over 4,000 Belgian adults, most of whom had cancer, chose euthanasia as well. My dad passed a few years back. He had debilitating rheumatoid arthritis, amongst other issues. He was a Korean War veteran and served our country with everything he had. When Dad was done taking his numerous pain medications, he courageously refused his medications to pass naturally. More recently, my mom has been in hospice for several months suffering from debilitating dementia and Alzheimer's. Hospice had 42 different medications available to end her life, but none to help sustain it. During Mom's final hours, she was offered oxygen to help her breathe, but not water or an IV. 2/3 of our bodies are made of water, right? Both Mom and Dad loved life. They wanted to live and not take their lives. They respected how precious life is. Mom passed in February of this year. I was right next to her when she took her last breath, and she said, Yahweh, Yahweh, the God of all creation, who she believed in with all her being. AB 345 is a doorway in support of people ending their life at will. Simply put, it's murder under the guise of compassion. Why are we not a generation of people that encourage one another to live full lives and add value to one another? Each one of us has so much to offer one another.
I need you to wrap up, please. Can you wrap up?
I will. We should not think of life as disposal. Legislatures, if you honor life and humanity, please oppose AB 346. Fight for the sanctity of life before there's no turning back in the legislative justification of exterminating humanity. I oppose AB 346. It legislates other professions to lie.
Please, we need to move to the next speaker.
Thank you. Please oppose.
Good evening. My name is Jesus Marquez. I am the co-founder and executive director of the American Christian Caucus, a faith-based grassroots organization that works with dozens of churches in Clark County as well as northern Nevada. I want to begin by acknowledging the deeply personal stories shared here tonight, especially from those who experienced the pain of watching a loved one suffer. I honor your grief. As a Christian organization, we believe in the sanctity of life, not just as a theology, but as a lived value. Every life, no matter how fragile or dependent, has meaning and dignity. That said, I stand respectfully in opposition of AB 346. Though intended as compassion, this bill opens the door to abuse, legal conflict, and emotional pressure on those who are already vulnerable. We've seen how the elderly and disabled can feel like a burden. This bill risks reinforcing that lie. It could also cause family disputes over whether someone was truly of sound mind. In our communities, we walk with people through their final days. Those moments, though hard, often bring healing and even spiritual reconciliation. Assisted suicide cuts that short. True compassion doesn't rush people towards death. It walks with them, offering hope and dignity. For these reasons, I respectfully urge you to vote no on AB 346. Thank you, and may God give you wisdom to decide properly.
Thank you. Next, please, in Las Vegas.
Hi, my name is Kerry Enright. That's Kerryenright, and I represent myself. I want to go back 2,000 years and read a passage from the Hippocratic Oath. With regard to healing the sick, I will take care that they suffer no hurt or damage, nor any man's entreaty prevail upon me to administer poison to anyone, neither will I counsel any man to do so. This is a foundational document of Western civilization. We are the kindest, most compassionate, most merciful civilization on the face of the earth, and we've been that way for 2,000 years. This is just not another bill. This is a fundamental change in the direction of our civilization, and we should not go that direction. Point number 2. You don't know when life is going to end. We had a woman in our parish 3 years ago who publicly announced that she was expecting imminent death because she had stage 4 cancer. She is now living happily with her family in New Jersey 3 years later. Point number 3, the testimony in favor of this said that this is going to be purely voluntary. Baloney. We had a very dear friend in Canada who was propagandized into MAID, and every time we talked her out of it, she kept on repeating the same propaganda over and over. We tried to say to her, she's valuable to us, but she was totally brainwashed. And so this is not a voluntary thing. This is a propaganda thing. And finally, what's the whole reason for this whole thing? Well, one of the supporters of the bill spilled the beans. She said, this costs the state nothing. Guess what? This is the reason for the bill. Let's kill this one more time. Thank you.
Thank you. Before we continue, are you Miss Hammond here? Brianna Hyman? Okay, we're going to come back to Carson City and let Ms. Hammond.
Oh. Okay.
Committee members, my name is Brianna Hammond. Do you know how depressing it is to come here every session to try to prove I am human and deserving of life? I'm sure by now you have all seen Elon Musk raising the Nazi salute and referring to me and those like me as the parasite class. And then Trump seeking to cut $880 billion from Medicare and Medicaid. The purpose is no different than at the T4 killing centers where Hitler started with people who had disabilities.
Okay. Okay. Are you done? Yeah.
Thank you. Let's go to the phones now. First caller on the phones, please.
If you would like to testify in opposition of Assembly Bill 346, please press star 9 to take your place in the queue. Again, please press star 9 to take your place in the queue.
Good evening, Chair. My name's Daniel Smith, DanielSmith. I can appreciate individuals going through, difficult times with elderly or those who have chronic or terminal illnesses. I came back from overseas, and my mother was terminal. As a matter of fact, the day I got back, hospice was brought in. 3 days later, she had passed, and she was a survivor of cancer for 8 years, but it came back. But that afternoon, my mother and I prayed together. And I told her, it's okay. You can go home to our Heavenly Father. And that evening, she passed. She was on pain medications and so forth, but there was no way she was going to leave without seeing her grandchildren. I'm a veteran. I've seen the death. Right now, I have a rare autoimmune disorder. I'm on a number of medications, but today I'm functional because of the technology and the research that has been done. I oppose this bill wholeheartedly for my personal reasons and my faith. And I heard someone that was, supporting this bill saying that, well, this is not suicide. I believe it is. And in my faith and in my understanding of my Lord, Jesus Christ, my Lord and Savior, that suicide is a sin. So I wholeheartedly oppose this bill. Thank you for letting me share, and God bless.
Thank you. Next caller, please.
Hi, this is Katrina Ivanov, and I am here to express profound disappointment that once again, that bill was proposed last time, is proposed again. We have so many problems that we need to be solved, and we are talking about the same issues, and it's not a helpful bill. There are places that pass that bill, such as Canada, which is the closest to us in many ways. So how about we wait another 5-6 years and see, because so far they've been literally killing their own population for no good reason. So far the results that are coming from Canada are not very optimistic, and is not something that we should be bringing to our population. I'm very disappointed with the legislature. They're
thinking of everybody else but Nevadans. They're passing bunch abuse, trying at least to pass bunch abuse to support people from other states, to support illegal aliens. Yet when it comes to Nevada, they want to kill us. It's mind-boggling. I apologize, but I'm very upset. And the testimony was quite long. After the phone, I hope you go back to Vegas. There's a lot of people in Vegas waiting to say something. And you guys, I don't believe you're looking at Nellis. Look at Nellis. Over 90% of the people that testify in Nellis oppose this bill. Do you really care about our opinion? Because it sure doesn't seem like you do. Please oppose this bill. Don't let it even come out of committee. Thank you. Have a lovely day.
Thank you. Next caller, please.
Good evening, Chair, Committee. Thank you for allowing us to testify. My name is Brianna Cowan, B-R-I-A-N-N-A, Cowan, C-O-W-A-N. I represent the Douglas County Republican Central Committee and the Douglas County Republican Women as the Legislative Chair. We are speaking today to express our unwavering opposition of Assembly Bill 346. AB 346 is not a compassionate measure. It is a deeply troubling piece of legislation that undermines the sanctity of life, erodes medical ethics, and places Nevada on a dangerous path of normalizing state-sanctioned death. At its core, this bill allows physicians and nurses to prescribe lethal medication to patients under the assumption that their lives are no longer worth living due to terminal illness. It turns a personal tragedy into a sterile, bureaucratic procedure masked in language like autonomy and choice. Let us be clear. AB 346 is not about autonomy. It is about surrender. It is about giving up on people at their most vulnerable. Instead of offering care, support, and counseling, this bill makes it easier to end life than it does to preserve it. It threatens elderly, disabled, and mentally ill, and those struggling through the dark moments of terminal diagnosis. It places tremendous pressure on those who already feel like a burden to their family, society, and the healthcare system. We must not open the door to quiet coercion where the path of least resistance becomes death itself. It erodes trust in medical professionals, and the public rightly expects that their doctors will work to heal them, to ease their suffering, and not to end their lives. There are no safeguards enough to eliminate abuse. No form, protocol, checkbox will prevent vulnerable people from making irrevocable decisions in moments of fear, depression, and misinformation. Once a life is ended, no regret or clarification can bring it back. I urge you to reject this legislation. Nevada should be a state that champions life at every state. We must stand for life, for dignity, and for true compassion. Thank you.
Thank you. Next caller, please.
Hello?
Caller, you're unmuted. Please go ahead.
Great. Thank you very much. Again, it's Ian McIntosh, IANMCINTOSH, Executive Director for Not Dead Yet. On behalf of members of Nevada and as a Canadian with disabilities living in America, I urge you to oppose AB 346. Ableism takes many forms, like legislatures that discuss real healthcare bills by deferring to authoritative organizations, but when talking about assisted suicide laws, ignore the overwhelming body of opposition, which raises the incredulous idea that all national disability organizations with a position, the AMA, the ACP, the National Council on Disability, and the UN Committee on the Rights of Persons with Disabilities, and its treaty based on the ADA, who are in reception of all available verifiable data are wrong while you are right. That is definitional ableism, which requires limitless terminological elasticity and camouflage, rendering words and promises meaningless, including terms like MAID, which intentionally cover assisted suicide and its intended iteration, euthanasia. But Jack Kevorkian had no problem calling it by what it is and noting its Nazi-era eugenical origins as something positive, saying, quote, I believe that there are people who are healthy and mentally competent enough to decide on suicide and, quote, intense emotionalism engendered by the concentration camp atrocities of World War II has unfairly stigmatized this honorable concept. Speaking of breathless comments, to the NB Compassion and Choices to the Nevada Compassion and Choices representation that the goal is to improve the quality of life, well, a CMC DEI advisor from Washington, D.C. said something different in the Maryland paper last year. Quote, I know in the Black community we're still fighting to live. We don't get adequate health outcomes to begin with, so it's hard to say, okay, let me offer you this option when you haven't been given the support you need to live. Precisely, because it's an obvious moral failing to fight for people to kill themselves in a vacuum created by lawmakers who should be the loudest voices in the room fighting for them to live. On behalf of Not Dead Yet Nevada, please confirm your opposition to the idea that suicide is rational just because you have a disability by opposing AB 346. Thank you.
Thank you. We'll do one more caller, please.
Yes, hello. Yes, hello. My
Please
name is
go
Kenneth
ahead.
Wilson. I'm here today to voice my opposition. Yes, my name is Kenneth Wilson. I'm here today to voice my opposition to AB 346 and also the father of a child with a disability. Paying doctors and nurses and pharmacists to kill their patients is absolutely the antithesis of healthcare. We're already seeing unscrupulous, low-standard doctors who will do any type of surgery, provide any type of treatment, no matter how unethical or controversial, so long as it pays. If we allow doctors and nurses to kill their patients or set up devices that will allow their patients to kill themselves, then guess what? Hospitals are going to become places where people go not to be cured, but to obtain the means to die. Doctors and nurses are not going to be people whom we trust for health, but rather potential executioners who look upon their patients as dollar signs. This is already happening in some of our Nevada hospices as patients' deaths are hastened so that hospices do not have to repay the government for patients who live longer than a year. Physician-assisted suicide has gotten so bad in the Netherlands that people actually carry a do not euthanize me card in their wallets because of mistrust for their so-called healthcare system. Couple this with people who have the power of attorney over elderly and handicapped family members, and this is a recipe for disaster. Have we forgotten Terry Chabot, whose parents and America watched helplessly and in horror as her husband withheld food and water from her until she died, a horrific death 2 weeks later, thanks to legislation and litigation just like this bill? This bill suggests that physician-assisted suicide is not to be considered, quote, mercy killing, euthanasia, assisted suicide, suicide, or homicide, unquote, but that is precisely what this is. Once again, legislators are attempting to rename the killing of people as something other than the killing of people. Citizens of Nevada, we absolutely and with healthy resolution reject this bill. Thank you.
Thank you. We have time for one more presentation. We'll do it in Carson City.
Committee Chair, my name is Kathleen Rossi. I'm a registered nurse, KATHLEEN-ROSSI from Reno. This bill claims to address two end-of-life concerns, pain and suffering and patient autonomy. However, I feel it fails on both accounts. Many who support these laws do so after a bad experience with the death of a loved one. I think it is important to acknowledge this sometimes is due to a misunderstanding of the natural dying process, and I have seen this in my career, where certain breathing patterns and bodily changes appear distressing but are not necessarily painful. A wise hospice nurse once said, "We labor into life and we labor out. What looks disturbing to us is not always suffering. When real suffering at death does occur, and it certainly can, and I don't doubt for a minute Mr. Dahlia's testimony, this is due to inadequate hospice care, not an inherent flaw in the dying process. The answer is not lethal drugs, but better funded hospice and training for nurses. Having assisted 4 family members in the last 5 years through their hospice journeys, I can testify hospice care varies widely and expertise varies widely. The answer is not to pass laws such as this. I believe they send a message to nurses that we'd rather pay for a bottle of pills than invest in your expertise and time, and to patients your care is too hard, too long, and we really need to speed up the process. Remember, autonomy is only one of the 4 core medical ethical principles, the others being malfeasance, beneficence, and justice. We don't have time to go into how they are all held in tension, but true patient choice means having access to quality care and support. Ironically, once these bills become law, patient choice does become lost and given to those that pay the bills. This is not progress. I take issue with saying that there is no escalation. That's simply not true.
I'm sorry, but I do need you to wrap up.
Just want to say one more thing. It has expanded. Last week, the United Nations Committee for the Rights of Persons with Disabilities urged Canada to roll back euthanasia. The fact that Canada is now combining assisted suicide with organ donation is beyond disturbing. I ask you as lawmakers, remember, hard cases make bad law. It's your duty to ensure that laws protect the vulnerable and not place them at greater risk. Please invest in true compassionate hospice care and not assisted suicide.
Thank you. I'm sorry that we don't have time for more, but I do want to get a count. If you wanted to testify in opposition and didn't get a chance, please stand up. We'll get a count. Also in Las Vegas, if you could stand up, if somebody could, can you count? Is there somebody, get a count in Las Vegas? 1, 2, 3, 4. Looks like we have 9 here. So we'll get that. How many in Las Vegas did not get a chance? All right, if somebody could give us a count, that would be great. For those of you who didn't get a chance to testify, for those of you who didn't get a chance to testify, you can submit written comment, and we will certainly share that among the committee members. So please do that.
There are 19 or 20 individuals in the
Okay.
room here in Las
So we
Vegas
have
that
about-
were not able to speak.
Thank you. So we have about 30 who were not able to speak, and we know there are a few more on the phone. We now have time for neutral testimony. So these are, if you don't support, you don't oppose, but you may want to provide information to us. Does anybody wants to testify in neutral here in Carson City? Okay, anybody in Las Vegas? Neutral? Anybody on the phones for neutral testimony?
If you would like to testify in neutral for Assembly Bill 346, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in neutral at this time.
Thank you. Would you like to provide any concluding remarks, Assembly Member?
Thank you, Chair, and thank you to the committee for Assemblymember Joe Daly for the record. Thank you for a long night, an emotional night. We've heard a lot of opposition here tonight, but I think much of it overlapped with the things we addressed at the outset. There are concerns about a slippery slope and other concerns that just haven't come to pass in places where this is legal. And I think a lot of care has been put into what this bill is. I think it was mischaracterized a few times tonight. And I just asked the committee to look to the facts, look to the language of the bill, look to the data, and please support this bill. It's going to help a lot of people. Thank you.
Thank you very much. Okay, this concludes our consideration of Assembly Bill 346. We will now take public comment, also limited to 2 minutes. And please remember that public comment is not about the bill. It's about the general topic for the committee. So.
For the record, my name is Melissa Clement. I'm with Nevada Right to Life, MELISSACLEMENT. I don't want to talk about the bill. I do want to talk about the process. This is a select committee. From what I understand, you wanted to do a combination select committee. which would have limited any kind of opposition to just the few people. This is a monumental decision you folks have in front of you. And it would seem to me that it is worth listening to people who made the time today with very few days. It was, what was it, Monday we found out this was going to happen? This is a legislative process. You guys have such incredible power. I urge you, look at those people that are down there. They took the time. It seems to me that you could at least listen to them. You don't have to agree with them, but for gosh sakes, listen to them. That's what your job is. You're elected to listen to them. Thank you.
Thank you very much. And again, we will rule. You may submit written comments. We would love to have more testimony, but please submit it in writing if you didn't get a chance. Or if you want to expound on what you said in your testimony, please submit it in writing and we will look at it. Any public comment in Las Vegas?
Hi, my name is Christiane Mersch, last name Mersch. Good night, members of the committee. I'm a board member of Nevada Right to Life, and I want to echo what Melissa Clem just said. It's very frustrating, this process, because we had a lot of people. We arrived here 4 p.m., 1 hour before. We signed the sheet. We did everything according to the process. We had so many people via Zoom that were not even here in Nevada testifying. So this is ridiculous. I'm just upset. I'm an immigrant in this country. I love that we can give our freedom of speech, and I feel censored. I feel censored because people took their time. And here we are again. We vetoed this bill 2 years ago. Here we are again because this is concern the community. This is not about economy. This is not about doctors. It's the community, and you need to listen to your community, please.
Next public comment in Las Vegas.
My name is Tim Underwood, Underwood. Board member for Moms for Liberty, Clark County. I'm a disabled Navy veteran. Been suffering from a debilitating brain injury since 2017. I have to say this. It is inappropriate for committee chairs to threaten jail time for alleged false evidence presented to this committee. You threaten us citizens of the great state of Nevada to intimidate us.
I'm sorry,
This is a First Amendment violation that must cease. When you say it's a misdemeanor to present false evidence to this committee, that evidence that opposes your false narrative is what actually is happening, and you quote this law about a misdemeanor. I want to ask, are legislators also subject to criminal penalty if they present false evidence to this committee? Yes. Are they?
Well, we have the same rule for everybody who speaks in testimony. But is there any other public comment?
So if I lie
I'm sorry,
and present false evidence, I can go to jail, and if you do, you go to jail too?
I'm sorry, this is not a question and answer. This is for you to make public comment. If you're finished with your comment, we can move to the next person. Thank you.
Yeah.
My name is Leslie Quinn, and I'm here to speak on the First Amendment. The First Amendment of the U.S. Constitution protects our 5 fundamental freedoms for all U.S. citizens: the freedom of religion, speech,
I'm sorry, this
press,
is
assembly,
the first
and the right to petition. This is my public
I'm
opinion.
sorry.
We're here to present
I know,
truth.
but you're supposed
Please do
to-
not weaponize your position as a legislator to
Please.
silence the Constitution.
You may talk about the topic of this committee. The First Amendment is not part of this committee. Next, please.
Hello, my name is Chris Marquez. You're asking everybody to come here and speak. You're limiting all of us. There's a whole room. There's about 30 people sitting here waiting. We all heard the time limits that you were going to give us to speak, and then you limit us. There wasn't enough time for all of us to speak. Why can't we all speak? Do you have a whole opposition? There's a whole room of opposition. There's mothers here with their children. I came with my children here to speak on this particular bill. Why can't we have the time to speak? Can you answer that? Can you tell us why?
This is common. I think everybody recognizes their time limits, and we would love to have all the time in the world, but we don't, and I'm sorry, and that's why we accept written statements. So please, all of you who didn't get a chance to speak, send us in writing and we will read it. Next.
Hi, my name is Kimberly Johnston Linsday. I'm a veteran, I'm a parent, I'm concerned about these issues, and to be told that this isn't a First Amendment issue, and I've waited here for hours with my newborn so I can discuss my feelings in opposition towards this bill this is heinous to me. My whole family is down here so we can show support for what your constituents believe. So get in Nellis, pay attention, read our comments. I feel extremely disrespected. I've witnessed people yawn, stretch, look otherwise disengaged, and as a voting member in this state, I'm beyond myself that this is how we're being treated. And that's all I have to say.
Thank you. We look forward to seeing your comments in writing.
Hi, good evening. My name is Grace Dre. I'm a public health nurse, and I represent all conservative nurses. And I'm kind of disappointed. We prepared our speech. We took our time here, and you just gave us like this false promise that you guys are gonna read. I'm 100% you guys will not take time to read because you didn't even take time to listen to us. How much more reading? If you won't even take time to listen to us when we are here, why would we even believe that you will take time to even read our notes? So that you guys are very hypocritical because you're asking respect from us, but you guys don't even respect the people who voted you in there. When you guys are putting laws that you guys not even respecting the voice of people because you guys are all have a motive for not for us, but for whatever motive money-wise you guys are doing. This is really disrespectful. So if you want some respect, please respect the voice of people of Nevada.
Let me thank you. I will remind you, we heard more testimony in opposition than in support, and we do read. We are respectful of you, and we look forward to your written submissions. Next comment.
Good evening. My name is Teresa Sharp, TheresaSharp. Ditto to what was just said. That was basically what I was going to say. And may I suggest that when that public comment time be expanded moving forward, there is a lot of things that need to be said, and reading something on a piece of paper does not have the same effect as it does when you are in front of a microphone with your emotion and your passion about situations. So please, I ask you if you would consider to expand time for when you want public comment on bills. Thank you.
Next, please.
Hi, I'm Danielle Evans, DanielleEvans. More of a question, since there didn't appear to be anyone who was neutral on the topic, and there was time allotted for neutral opinions, and there's time for public comment. Is it possible, since there are several people who have testimonies prepared in opposition to the bill, to translate that time instead for us to present our testimonies?
We've used up all the time. I'm sorry.
Okay, thank you.
Do we have any callers for public comment?
If you would like to provide public comment, please press star 9 to take your place in the queue.
Hi, my name is Katrina Ivanov, and I want to ask the committee to really look into the Nelly's result and to make it feel like you guys are listening to us, because obviously you hear the testimony. Nobody feel hurt, nobody feel, and I understand you gave more time for the people in opposition, but in comparison, we had a lot more people for opposition, and there was a lot to oppose on that bill. And honestly, can you please start making laws that are not restricting our constitutional rights, that are thinking about Nevadans? Stop making laws that are beneficial for people from other states, from people from other countries, and use our taxpayer dollars for providing benefits to people that didn't pay into the system. I don't know, what do you believe your job is? Are you guys serving the special interest people? I'm really mind boggled, because if you really are there to support your constituent opinions, I don't see that happening. I'm sorry. I'm really upset with what is going on with this bill and the other bills. So I hope you start listening to us. Thank you so much for staying that long. Have a lovely evening.
Thank
Bye.
you. Next caller, please.
Chair, the public line is open and working. We have no additional callers for public comment.
Okay, I see we have one more person here.
My name is Lisa Bedotto Laughlin, Lisa Laughlin. I'm glad I came down today, even though I was not able to give my testimony in opposition, and I will submit it in writing. But I will say that the experience was a little disappointing, that we didn't get to speak, and that the time that was allotted for neutral wasn't given to those in opposition. It felt disrespectful. And I heard something the other day on TV, and today just made it so clear. And it was that everybody has a lobbyist except the people. No one listens to us. That's how it feels. Thank you for being here tonight.
Thank you for coming. Before we wrap up, are there any comments from members of the committee before we adjourn? Okay. See no further business before us, this meeting is adjourned. Thank you all for your participation.